Chapter 6, Intellectual Property, Part 2B, Liability and Infringement. The learning outcomes include: compare and contrast two types of liability, contributory and vicarious. Describe the substantial similarity test and how it is used to evaluate potential copyright infringement. Address the current use of digital sampling and how that affects potential copyright violations. The two types of copyright infringement are contributory and vicarious liability. In the upper right corner, you see an image of a YouTube video that was removed due to numerous copyright violations by the user Lego Boy. Lego notified YouTube of copyright infringement and they removed the video. Lego has to be vigilant to protect this copyright. A few years ago, my husband recorded a few high school baseball moms doing a dance for their sons on senior night. I wasn't in the video, thank goodness. Unknown to my husband, a song was playing in the background, possibly even on the lacrosse field, not our field. YouTube notified me of copyright infringement. He posted all his videos on my account. My husband came home from work complaining, saying they couldn't take down the video. I said, yes, they can. Ultimately, the video was allowed to be reposted, but is unavailable in one country, I believe. With contributory liability, you should know that something is protected. For instance, we all know that we shouldn't download music that doesn't belong to us any more than we should take a candy bar from the store without paying. But how many of us have had a hypothetical friend who has downloaded songs and kept doing it even after it became crystal clear that it was illegal? With contributory liability, you also may have encouraged it or could have stopped it. Perhaps the parents of the child who downloaded thousands of songs, for instance, could have stopped it had they installed a filter or even just talked to their child. The critical factors for contributory liability are knowledge and purpose control. If the purpose is to make money or to illegally share files that aren't yours, then you may move to a more significant violation of copyright law, vicarious liability. With vicarious liability, you know that it's illegal and you could have stopped it or minimized it, same as contributory. However, vicarious liability goes further. You make more money when others infringe. The focus here is on money and control. Penalties are typically much harsher for those found guilty of vicarious liability. Here's one way to look at copyright infringement by overlaying it with plagiarism. First, you see the graph that includes moral and legal groups. With plagiarism, you're likely going against your own morals. Who amongst us wants to cheat, even when we know it's not the right thing to do? Particularly for graduate students, I believe most are accidental plagiarists. The penalty is typically the same, but it's a lesser offense. If, however, you take a significant portion without permission or attribution, you have moved to copyright infringement. Looking at the second representation of plagiarism, the author compares it in ethical and legal ways. If you don't cite or give proper credit to the original author, if you copy or buy a paper to submit as your own, or if you use someone else's ideas and present as your own, you are likely behaving in an unethical manner. You move to copyright infringement and could face civil and/or criminal charges if you reuse a work without permission, incorrectly trying to claim fair use for educational, satire, or news reporting use, or don't obtain a license for a copyrighted product that requires them. That's copyright infringement and is illegal as well as unethical, and likely immoral as well. These two drawings do a great job of presenting a complex concept and relating it to something we're all familiar with in a clear and concise manner. When someone accuses another of copyright infringement, the substantial similarity standard is often called into play. The copyright holder needs proof that the person copied the work in an illegal or improper manner. The product cannot be the result of two or more artists independently arriving at the same creation. That is, they expressed the ideas in the same or almost the same manner, but they independently came up with the expression. Copyright also does not protect against independent creation of the same or very similar manner of expressing ideas. When considering whether copyright infringement has taken place, the authors or their legal teams try to evaluate if the person they believe infringed had access to the work in question prior to creating their own work. If the person had access plus a substantially similar expression of ideas, the courts consider the product or service to be copied, and the copyright protections have been violated. For instance, if you come up with a first-person shooter game that looks remarkably similar to Call of Duty 4, and your little brother played Call of Duty 4, and you likely saw it, then you can't claim you didn't have access. The only thing left is determining if it's substantially similar. Let's travel back in time a bit and look at how computers developed and a famous case that was litigated between Microsoft and Apple. A couple of key things to notice in this timeline. In 1983, Apple introduced a graphical user interface. You could use pictures of common business icons like a file folder, trash can, and printer to choose what you wanted the computer to do. You also had a pointing device called a mouse that you could use to click on your choice. If you look at the second arrow, you will see that Microsoft Windows didn't come out until 1992, almost 10 years later. Let's take a closer look. Here's a late 1980s dual-drive PC. In the picture, the computer is using two 5¼ drives, although later models had a 3½ with more storage capacity and greater durability. The next picture shows a graphical user interface that accompanied the PC running MS-DOS. Do any of you remember this? In contrast, here's a picture of a Macintosh 1 from about 1984 and a picture of the graphical user interface that accompanied it. I remember first seeing the Windows used by Macintosh and being amazed. However, Apple computers were significantly more expensive than PCs and thus didn't make large gains in business and home use. Here's the graphical user interface that Microsoft released in the 1990s. Although it's in color, it's awfully similar to the Apple interface. Let's take a look. The graphical user interface on the left was in black and white, and Microsoft 6 to 10 years later used color. Do they look very similar to each other besides that? I'll let you be the judge. Having been there when both products came out, there's no doubt to me that Microsoft had inspiration from Apple and were building on the shoulders of giants. Apple said they copied us and took them to court. Apple said that Windows was similar to the GUI in Lisa and Macintosh. Apple had registered its graphical user interface for a copyright as an audiovisual work. However, upon review, the court ruled that many aspects of Apple's graphical user interface were not eligible for copyright protection. The court said that using Windows to show images was not new or novel or non-obvious. People looked out their windows all the time and could see similar objects. The windows did make it easier for users to interact with the items, but that was ruled to be the idea and not the expression of the idea. Yes, they both used the trash can and a file folder and such, but there was nothing new about that. You clicked on the printer when you wanted to send something there. Or you powered on the Xerox to get, just like you powered on the Xerox to get a copy made. The menus did save space and made it convenient for users, as did allow them to open and close objects in a consistent manner. But neither of those ideas was protectable. Ultimately, the courts decided that they had to first remove the ideas not eligible for copyright protection. Then they found that so little of the graphical user interface was protected by copyright that there was little left to compare. For the small amount left, the items would need to be directly copied for infringement to have occurred. Thus, Apple lost the case. I urge you to follow the excellent timeline representation on YouTube. It compares Apple and Microsoft side by side for 30 or more years. It's well worth an investment of less than 10 minutes of your time. If you recall, copyright owners have all rights to derivative images. Cleanflix Media attempted to take out the bad language in movies and make it suitable for families. However, they stored a copy of the edited movies on a server for customers to view. In the mind of copyright holders, that was an unapproved derivative work, and Cleanflix couldn't do it without permission. While the Family Movies Act of 2005 makes it legal to use filtering technologies for just this purpose, it does not allow you to keep permanent edited copies of the movie. That's not how the director, producer, writer, actors, etc. want their work to be portrayed. In the end, VidAngel emerged to filter bad language and sex from movies, but without making permanent edited copies of the movies. You can take a look at the short YouTube video to see how VidAngel describes itself. Who can forget the absolutely iconic image of Barack Obama's Hope poster? The poster was created in a day by a street artist, Shepard Fairey. It was used in 2008 and in 2009 and ultimately made it to the Smithsonian. However, several groups came out and said that the photo was theirs. You can see the 6 photos that purported to be the basis for the Hope poster. In the last sequence of pictures, you see the AP photo by Manny Garcia from 2006 on the left with a closer view in frame 2, and then the final image in frame 3. Ultimately, Shepard Fairey received about a $25,000 fine and 2 months of probation, in part because he destroyed documents that showed he had seen the AP photo at some point prior to creating the image. Have you read The Da Vinci Code by Dan Brown or seen the movie with Tom Hanks? Louis Perdue challenged that his earlier book, Daughter of God, was unfairly copied to make the Da Vinci Code. If you remember, the Da Vinci Code talked about various religious themes and historical legends that were common knowledge or ideas. While the 2 books were very similar, the courts decreed that the similarities were ideas. Since ideas cannot be protected, but only how the ideas are expressed, there was no case. As U.S. District Judge George B. Daniels ruled in April 2006, quote, "A reasonable average lay observer would not conclude that the Da Vinci Code is substantially similar to Daughter of God. So our reasonable person came back again, and we'll keep seeing this person who isn't always so reasonable." Further, Judge Daniels said that, quote, "any slight similar elements are on the level of generalized or otherwise unprotectable ideas." In another high-profile case, Joe Satriani, do you know him? Accused these people, Coldplay, do you know them? Of copying some of his material in Viva La Vida. The suit was dismissed from the court in 2009, although there were indications that a private settlement was reached. If you only watch one YouTube video in this class, take a look at this one, which overlays the music for you to see the similarities. It's only 1:50 and it's a worthwhile investment of 2 minutes of your life. Was there substantial similarity? Access plus copying? I'll let you decide. Enjoy. To summarize, we looked at how copyrights have taken to the courts to try to settle disputes with the movement toward digital technology. Laws and regulations haven't kept up with advancements, so it's hard for judges to make interpretations. In addition, although hindsight is 20/20, oftentimes an idea that seems commonplace now was so different at the time it was introduced, like Macintosh's use of Windows and a mouse. we discussed several types of infringement and some of the penalties that may be imposed. It's difficult to prove that someone directly copied from your idea. Ideas aren't protected, but the expression of the idea is protected.